Because I don't see how I can bind that gentleman over on these charges without somebody to say, this is the guy that we searched his house and we searched his vehicle and we searched his backpack. And give me, I'm willing to listen to anything you got to tell me today, but until I hear somebody say, yeah, that's the guy that was the subject of the search warrant, I don't know how I bind him over. I don't think there's anything vague. Let him listen to me for just a minute. Sorry. I don't think there's anything vague in the wording of the search warrant. It says target suspect, target vehicle, and then it says furthermore, any other vehicles that are located on the curtilage.
Substances and pills that were recovered?
Correct.
And did you field test some of the drugs and use drugs.com to identify some of the pills that were recovered?
That is correct.
Okay. And how did you identify evidence tag item number 3?
Number 3, I utilized TrueNarc.
And what did it test as?
Methamphetamine.
And did you, what about evidence tag item number 4?
Number 4, drugs.com was utilized.
Your Honor, actually, I'm going to object. I want to list it for item number 3 to ensure that the rule says that the results of a properly performed drug analysis are admitted. I want to make sure that it was properly performed before taking that as substantive.
You want to go here?
I can, if
Go
that's
ahead.
okay. Unless you.
I can answer, yeah. You said you used a TrueNarc to field test item number 3, is that correct?
Correct.
Can you explain what a TrueNarc is?
A TrueNarc is a handheld device that it uses laser technology that you hold up to the substance that you want to test. It reads the chemical compound, it analyzes it with inside its own database, and then it will give you a reading as to what that what it is that you're testing at that time.
And have you been trained to use that TrueNarc machine?
Yes, I have.
And did you receive some sort of certification after you were trained in using that machine?
Yes, I did.
And as of the date of April 14th, 2021, were you certified and was your certification current to be using the TrueNarc field testing machine?
Yes.
I'd pass it. Defense counsel has any additional questions?
I suppose, what is the procedure when you, obviously you described the general mechanics of it. What is the procedure when you are supposed to, the procedure for using the TrueNarc test?
The procedure that is used is you turn on the device, you use a self-check, then you use it to test your compound or whatever it is that you're testing at the time, then you self-check it again.
Okay, do you have to mash up the pills at all? How does it take a sample?
No, you don't have to mash up anything. You hold the sample, you take it and you hold it directly on the point where the laser comes out, the laser beam comes out, and you push scan.
Okay, and you did that in this case?
I'm sorry?
You did that in this case?
Correct. There was a self-check to make sure that the device does its own internal self-check, that it's working properly. Then I did the sample and then I self-checked it again.
And the self-check, did that come back is that like a negative result or nulling out the machine?
Correct. It literally says self-check pass. That's how it comes up.
Okay, and it said pass on that one?
Correct.
I am.
Proceed, Mr. Gerstein.
And evidence tag item number 4, how were you able to explain what you did for evidence tag item number 4?
For all the pills that were recovered, drugs.com was utilized to identify the pills.
And Your Honor, I will object to any hearsay from drugs.com. That is not a preliminary analysis of drugs within the meaning of the rule.
Judge, I do have, if Your Honor would like me to pull it up now, I do have the case law that indicates that drugs.com is a viable means for officers to preliminarily identify pills before a MSP lab test is done. I do have that on my computer. I can pull up, or if Your Honor would like us to continue taking testimony and then we can supplementally brief that issue, whichever Your Honor prefers.
Let's talk about it after we're done with testimony.
Okay. And what was item number 4 identified as?
Item number 4 was identified as L-pramazole.
I'm sorry, what was that item?
L-pramazole, Alprazolam.
And how many pills?
It was 2 milligrams and recovered was 173 units, also known as Xanax.
And what about evidence tag item number 5?
5 was identified as oxycodone.
How was it identified?
I'm sorry, through drugs.com.
And how many pills were
There
recovered?
was 10 units, 30 milligram pills.
And what about evidence tag item number 6?
Number 6, identified by drugs.com as oxycodone, 27 units, 30 milligram pills.
And what about evidence tag item number 7?
7, drugs.com was utilized, oxycodone. There was 2 of them.
And
That was the one that had the half Xanax and the 1.5 oxycodone together in the unmarked pill bottle.
and did you author the search warrant in this case?
Yes, I did.
And did you include any vehicles in that search warrant?
Yes, the Ford Fusion.
And was that Ford Fusion in the search warrant to be searched wherever it is located, or just on the property?
Your Honor, I'm going to object. Whatever the officer's intention was with respect to the contents of the search warrant, I think are irrelevant. The question is whether or not what the court authorized. I think we'd have to deal with that separately as a legal question.
Well, Judge, I think it's clear from the language of the search warrant. There's language that says any vehicles on the curtilage, and then there is a separate line that just says this vehicle.
Judge, I think we'll have to address that in motions after the testimony. I don't think this officer is able to testify. It doesn't matter
I
what her
agree.
intention is.
The document speaks for itself, and she's not the one to interpret it.
Okay, thank you, Judge. I have no further questions.
No offense, Sergeant.
None taken, sir.
Your witness, Ms. Cordles.
I don't think I have any questions. Ultimately, yeah, no questions for this witness.
You step down.
Thank you.
I'd like to give a citation for that drugs.com case,
Yep,
please.
absolutely. I'm gonna pull it up right now. And Judge, the people have no further witnesses. I can pull up that research real quick if the court would like.
Mr. Cordles, any witnesses from the defense?
No witnesses for the defense, Judge.
Thank you. Go ahead, counsel. Pull it up.
Judge, at this time, the people would move, well, to bind over the defendant, but would Your Honor like to wait until we resolve?
That's all right. We can start argument while you're digging through that.
I guess we actually might be able to skip that argument depending on, I would make an objection and I would lead with the search warrant issue. And obviously, I don't know if the court has a copy of the search warrant in its
I
file.
don't.
The people wouldn't mind, I would actually move for admission of that document, so the court can review it, obviously subject of this issue. I'll move for it as defense exhibit A if the people don't want to admit it as theirs. That's okay?
Yeah, that's fine. I have no objection to the admission of the search warrant.
Thank
Do you
you.
need a tag on this, Judge?
Say again?
I've got tags. Do you need a tag on this?
Yeah, she's gonna mark it.
Okay.
Go and staple that too. That's one document. Thanks. No, I don't want that. Go ahead.
All right, Judge, so looking here, I think the relevant information is contained on pages 2 and 6. But starting with page 2, it lists a target subject vehicle in which that Ford Fusion is listed. And then there's a last paragraph on page 2 that says any vehicles parked in it says furthermore, any vehicles parked in the driveway, garage, lawn, etc. But if you scroll down to page 6, in the very last box where it says in the name of the people of the state of Michigan, that's the part I read into the record earlier, that talks about searching the location and seizes the described property. Now, it seems clear to me that reading this search warrant, it seems to be limited in scope to the property and vehicles located on the property. It doesn't say that this vehicle anywhere can be searched. That vehicle is only mentioned in passing as a target subject vehicle. It's not explicitly listed as an item to be searched. And I think without that kind of clarity, the officers did not have probable cause or some other warrant exception to search the vehicle away from the property. The warrant should have been much more specific if they intended to search it when it was not on the premises.
If they would have found Mr. Fry out in the public street, would you think they couldn't search him?
They could search him. In fact, I think there would be independent basis. We didn't get into that on the record. Searching his person, incident to arrest, would certainly be one way to do it. But these officers are saying that they performed there was a traffic stop on this vehicle away from the property, and that the trunk of the vehicle was searched in that locked container.
He's walking down the street. They know he's the guy that's subject to the search warrant, but he's not home yet. They stop him and search him. You're okay with that?
I think that would be authorized because the warrant indicates the search will include the person of Fry Timothy Rain. It says specifically the search will include this person.
Okay. And how is the subject person different than the subject vehicle that's listed on page 2.
I see where the court's going with this. I just don't think the warrant is specific enough to draw the same
Then
authorization.
explain to me the difference between the subject, the target subject, and the target vehicle. How are those two things different that they can allow the cops to search his body but not his fusion?
Because in the initial part of the warrant, it describes the property first. Then, obviously, it says this section of the search will include the person of Timothy Fry. But then the next section of target subject vehicle doesn't say anything about the search will include, the authorized search includes this vehicle. It just says this is the target vehicle. In context, I think that you have this exception where on the first line where it says the search will include, that same language isn't found later. If there was an intention to allow the search of the vehicle anywhere in the world, then I think that should have been more explicitly stated in the warrant. As it is, it's sort of vague, and I would say that vague. I know obviously in statutory construction, the rule of lenity would say you should find in favor of the defense for any vague term. Obviously, this is not a statute, not quite the same, but ultimately, I think without an explicit call to search the vehicle anywhere in the world, that it should be limited in scope to the property, which is the header of the search warrant, and also sort of mirrored in the conclusion of search the location and the described property.
Okay. Anything else?
have to save the rest for the drugs.com argument. Those are my only two. I will also add that there was no identification on the record.
Ms. Biggerstaff?
Judge, in regards to the search warrant, I think it is clear that the vehicle is listed as an item to be searched separate from any vehicles that are located on the curtilage. It is specifically listed as the target vehicle, and then that vehicle is listed separate from items on the curtilage. So I think it's clear that this vehicle is to be searched wherever it is located. In addition to the drugs.com, this is People v. Nolan, a 2016 Court of Appeals case number 326970, which indicates that the Court of Appeals actually allowed drugs.com for identifying drugs in a jury trial, indicating that it was the trier of facts rule to determine the weight and credibility of the officer. Her testimony was sufficient to establish the pills recovered from the defendant were controlled substances for purpose of possession of the controlled substance and possession of controlled substance. And those were identified. The Court of Appeals indicated that although she did not perform a chemical analysis, she testified that she made the physical identification by viewing the markings on the pills and using an online database containing information on all pharmaceutical tablets, which is what we did here. And that was the 2016 Court of Appeals case. And there's also a 2009 Michigan Court of Appeals case, People v. Amsden, AMSDEN, which indicates the inability to chemically analyze the loprazolam found in the defendant's room did not render the evidence insufficient where the substance was identified by comparing unique markings on the pill against a national database compiled by the manufacturers of prescription drugs, which is again what we have here with drugs.com. So I would submit to this court for probable cause purposes for a preliminary exam. The officer identifying those pills by drugs.com is valid, and that testing should be allowed in.
Judge, what was the citation for Amsden? Oops. Hold on, just close it.
Sorry. Number 280194, 2009 Westlaw 323475 on page 2.
Got it, thank you. All right, Judge, the reason I asked for those citations is these are unpublished cases. These are not precedentially binding. I also think it's interesting with respect to Nolan that it describes a jury trial. We don't know what the authentication steps were precedent to the admission of the drugs.com steps. Certainly, it doesn't sound like the case was interpreting the statute at question here, which I believe is what 766.11b is what we're talking about for the admission of a analysis report for this stage. When all the people can cite are unpublished cases from some time ago without the current Supreme Court composition, there's no published case on point saying that they can use drugs.com. It doesn't fit within the meaning of the plain language of the rule, which says a chemical analysis or drug test. This is like a visual comparison from hearsay documents. I'm not seeing how the people are getting the drugs.com stuff in. It's just hearsay.
And Judge, if I could indicate, defense counsel is citing Rule 76611B for admitting reports. The people are not seeking to admit any reports. People are relying on the testimony of the officers and what exactly they did. People are not seeking to admit the reports from the field testing. So I don't think that rule even applies, because that rule specifically applies to admitting reports at an exam, which is not what people are trying to do.
Judge, and the people have a different problem if that's the case, because now they're introducing basically the results of a field. But they're trying to make this a kind of field test without admitting a report. They're not even proposing to put into evidence the drugs.com printout that they used to compare. So how is the trier of fact supposed to check this at all? The people are allowed a wide berth of hearsay in proving drug charges by using this preliminary analysis. They've done it with the methamphetamine charges, at least, although they only orally described the TrueNarc report without actually authenticating it into the record. I think without that, they don't have probable cause. They have to show you something in evidence. The officer can't simply testify, oh, this was the result of this, this was the result of that, without admitting that report. Otherwise, I don't see where they get probable cause out of that. You can't just skip around the evidentiary rules by saying, oh, well, we didn't admit the report. That's the whole reason that testimony was not objected to, is because it's 766.11B territory, but the report, I think, would have to come in for that.
There is absolutely no requirement that the people submit anything at a preliminary exam. Exams are always testimony-based. There's no requirement to submit any reports to Your Honor. Your Honor is the trier of fact for this hearing, determining whether this case will be bound over to a probable cause standard. Your Honor heard the testimony. Your Honor can either accept the testimony or not, but I think the officers indicated they all have several years of narcotics training, have several decades of experience as police officers. So Your Honor can accept or not their testimony, but just because there's no report does not invalidate everything they testified to, just because the people chose not to submit a report. There's no requirement for that.
All right. Let's talk about his third issue. Mr. Fry was not identified today on the record.
That's correct, Judge. I think the first trooper, Keller, indicated that this individual was arrested while he was not the individual that conducted the traffic stop. I believe he did testify that Mr. Fry exited the home. They watched this individual get into the vehicle, leave the home, and then he was traffic stopped a couple blocks away from the residence, and that Mr. Fry was the individual listed as the target subject on the search warrant, and then subsequently arrested inside the vehicle before Trooper Keller arrived to do the search of the vehicle. So while Trooper Keller didn't specifically identify this defendant sitting here, I think there is circumstantial evidence and testimony that was presented that Timothy Fry was the individual in the vehicle. Additionally, I do believe that the people have, to a probable cause standard, proven that the defendant was the individual in the vehicle, driving the vehicle, the sole occupant of the vehicle. Trooper Keller did testify at the time of the traffic stop.
Judge, I don't know how people can say that without having a witness get on that stand and say, I recognize this individual sitting next to defense counsel wearing this clothing as the Timothy Fry that's described. It's a procedural thing that they do in every case. I don't know why they didn't do it here. If these witnesses just didn't have the right knowledge, I don't know, but they didn't do it. I don't know how the people can just toss up a name and that automatically translates into probable cause. I don't think that works.
And if I could say, I know the defense counsel is trying to push the people into presenting their case in a particular way, but it is not true that in every single case someone gets up on the stand and says, that's the guy who points the defendant. There are ways for identification to be proven in cases to be bound over without someone sitting on the stand, pointing the defendant, identifying them by name, and describing their clothing. So I think while defense...
Well, let me stop you, because it's never happened in my 22 years on the bench. So explain to me how you're going to do it today with nobody saying that was the guy that was in the Fusion that got stopped.
I believe that the Trooper Keller did testify initially that the individual that was arrested was Timothy Fry. And the individual that is before Your Honor today is Timothy Fry. I guess maybe if Your Honor would allow supplemental testimony from Trooper Keller on this issue, if we could reopen the proofs briefly.
Well, if he's still here, let's do this first of all. I don't think there's anything vague. Let him listen to me for just a minute. I'm sorry. I don't think there's anything vague in the wording of the search warrant. It says target suspect, target vehicle, and then it says furthermore, any other vehicles that are located on the curtilage. So I think the search warrant certainly covered the Fusion, even though the Fusion wasn't at the house on Wexford or that specific address on Wexford. I'm also going to allow, for probable cause purposes, the testimony that I heard today without any reports or anything else, to establish probable cause that the substances that were found were contraband and controlled substances. Now let's put your trooper on the stand so we can take care of an ID issue.
Thank you, Judge.
Trooper Keller, you're still under oath. Come on up. Watch your step on my ramp. You can bring that with you. You're all right.
It's upside down. It's right here.
Proceed, Ms. Biggerstaff.
Thank you, Judge. Just to back up, so when you were searching the black backpack that you found in the trunk,
Yes.
are there any other items you recovered in that backpack that you did not previously testify to?
There could have been. I would just have to refresh my recollection with the report.
Did you recover any paperwork from inside the backpack? Would looking at your report.
Yeah, I would need the report just to double check. I apologize.
May I approach the witness?
You may.
Figure out what that ticket is. I can't, from those alphabets there, I can't figure
Okay.
Did that refresh your recollection?
Yes, ma'am.
Did you recover any paperwork from inside the backpack?
I did recover it. It was not seized.
What did you observe in the backpack paperwork-wise?
Paperwork for Mr. Timothy Fry.
Your Honor, I'll list an objection for best evidence rule. If the paperwork was not seized and is not being offered into evidence, the contents of a writing can't be testified to by a witness if they're contained in a writing. I don't know if they're still on evidence or not. They say they weren't seized, but it's not clear what was done with it. Not meeting any one of the other exceptions, I believe it's contained in MRE 1004. People can't use that witness testimony to testify as to what's on the writing.
Judge, he can testify as to what he observed. I'm asking him what he observed in the backpack, just like everything else he's testified up to this point, what he observed in the backpack that hasn't been produced. People don't have to produce the writing in the backpack.
I just don't see how this is different than if, let's say, the officer watched the surveillance video and then comes into court and testifies to what he saw in the surveillance video when he wasn't a firsthand witness to the events contained in there. This would be the same thing, in my opinion.
He is a firsthand witness. He opened the backpack and he saw it.
He's a first, yeah. Hold on just a minute.
Oh, thank you.
Flesh it out. What do you see?
What type of paperwork was in the backpack?
I can't recall the exact type of paperwork that was in there, but it did have Mr. Timothy Fry's name on it.
And before you made the location to search the vehicle, well, let me ask you this. Do you recall if it was like a bill, a postcard? Do you have any recollection as to what the item was?
Not 100% unless there was a photograph of said item taken. But like I said, I can't be 100% certain, and nor do I want to stick myself in testifying to something specific in it not being 100% accurate.
Okay. And if I could just have a moment, Judge.
Sure.
And you indicated that looking at a picture may refresh your recollection as to what was recovered from inside the backpack?
Yes, ma'am.
May you approach the witness?
You may.
Do you recognize what you're looking at here?
Yes.
And for the record, I have shown this to defense counsel previously, is that correct?
Yes.
Okay, what are you looking at?
It appears that it's a referral order from something medical.
Your Honor, I'm actually going to object if she's refreshing recollection. He's not going to be allowed to testify to what this is without moving for its admission.
Do you recognize this document?
Yes,
How do you where do you recognize it from?
inside the vehicle.
Okay, what is it?
It's a piece of paper with Mr. Fry's name on it.
What type of document is it?
It's a referral order or a piece of medical documentation with his name on it.
Okay, did you recover, how many of these documents did you recover from inside the bag?
I can't exactly say how many documents were inside the bag, but in that photo, there appears to be 3 photos.
Do you recall there being more than one?
Yes,
Okay, do you recall there being about 3 medical documents inside the bag?
yes.
And before you made the location of the vehicle to search the vehicle, did you receive some information as to any occupants of the vehicle?
Yes, that Mr. Fry was the sole.
Your Honor, I'm going to object for the hearsay component of that, or at least it should be taken for a non-substantive purpose.
I think it goes to the effect on the listener. In the course of the investigation, he received this information, and based on the information he got, this is what he did next.
And that
Maybe, let's find out.
Yes.
Judge, I'll just say, request that the court take that for a non-substantive purpose.
I got you.
What information did you receive?
Prior to us executing the search warrant, Mr. Fry had left his residence in the suspect vehicle, which is the black Ford Fusion, and a traffic stop was going to be conducted on him. He was the sole occupant of said vehicle. Traffic stop was conducted on him. This was all relayed to me via radio and or communications. We executed the search warrant, and then Mr. Fry was subsequently taken to, I believe it was Van Buren Township Police Department for lodging, which is at which point in time I left the search warrant at the residence or the venue that's described here. I went over to the location where the traffic stop was conducted, saw the suspect vehicle, verified it was it. It was unoccupied at the time. I conducted a search of the vehicle.
Did you ever go to the Van Buren Township where the suspect was lodged?
Negative.
Okay. Before the search warrant was conducted, was a briefing done?
Yes.
And was part of that briefing on the target subject that you were investigating?
Yes.
And were you given some personal information about the suspect?
Yes. His name, date of birth, race, height, weight.
Okay, and do you remember the date of birth that was provided in the briefing?
Your Honor, again, I'm going to object. This is hearsay. I don't know. Obviously, the people are trying to do this for the course of the investigation. It's all non-substantive. I'm trying to understand what the relevance is if it's non-substantive.
Relevance.
Judge, I think this will go for identification. If the trooper can indicate the birthday of the suspect that they were looking to investigate, and then the individual that was stopped is that same individual let me back up, I'm sorry. During the briefing, they were given the name of the individual, the birth date, and a physical appearance, which the trooper just testified to, asking what those qualifications were. Then the trooper testified that the officers saw this person leave the house, get into the vehicle, be the sole occupant of the vehicle, be traffic stopped, and then be arrested. And then be lodged based on that. And I think it's relevant, the physical characteristics and the birthday and the name of the individual they were investigating, because they indicated that that was the individual they saw come out of the house and was subsequently arrested, and it would go to identification, which is the purpose for this officer taking the stand.
And Judge, that's all fine and well. The problem is all of this is for a non-substantive purpose because it's all hearsay. So what difference does it make what the birth date and description was given if it doesn't come in as evidence? It's all it is coming in as an indication of why this officer did what he did, but not for a substantive purpose. The people want to use it for identification, which is a substantive purpose. I don't see how that works.
If this trooper never came in contact with Defendant Fry, how's he going to identify Defendant Fry?
He's going to identify the suspect that was the target of the investigation. The suspect that they were briefed on. And then based on his knowledge of the investigation and what he has participated in, that suspect of the investigation is the same individual they saw come out of the house and the same individual that was traffic stopped.
So he's going to identify the man in the chair in the blue based on general physical description and date of birth that was given to him in a briefing?
Potentially.
And Judge, I think it's a bigger problem than that because they're relying on hearsay from the officers who conducted the surveillance of this suspect leaving the location and making the assertion that he was the sole occupant of the vehicle. If this officer never encountered that subject, we're importing hearsay from these other officers without taking their testimony.
And Your Honor, in that case, well, aside from the issue of this officer, the people would ask this court respectfully if we could hold this exam in part and bring in the trooper that did the traffic stop to have his testimony as to who he traffic stopped and clear the issue up.
That would do it.
Yes.
Because I don't see how I can bind that gentleman over on these charges without somebody to say, this is the guy that we searched his house and we searched his vehicle and we searched his backpack. And give me, I'm willing to listen to anything you got to tell me today, but until I hear somebody say, yeah, that's the guy that was the subject of the search warrant, I don't know how I bind him over.
Yes, Judge, and that the people would respectfully ask to come back another day and have that trooper come and testify before Your Honor as to his participation in this traffic stop and what he observed.
Mr. Ordos?
I will list an objection that the people should have come prepared today, knowing their own case, to prepare and have the right witnesses. I'll also indicate that Mr. Fry has been incarcerated for some time, obviously ever since April of this year, on a parole absconder status. He caused to be delivered to the people a 180-day letter, which took until July to do. So his case has been pending for a very long time. I think any adjournment should not be permitted to the people to make up for their own faults. This is something that should have been foreseen by them as an issue, and the court should not reward that kind of negligence. I think the proper remedy here is to dismiss the case, and if they decide that they've got enough evidence to come back, they can come back and perhaps even order the transcript of this proceeding to save them from having to recall the same witnesses.
I don't entirely disagree with you, but in the interest of efficiency, let's find out how long it would take to get a trooper here. Why don't let me just pass on this for a few minutes, find out, what's the trooper's name?
The people would be calling either Belleville Officer DeVos or Sharkengoss are the two that did the
Even
traffic.
better than a trooper. So make some phone calls, find out how soon we can get somebody here. We might be able to do this today.
You want me to call him right now?
Yeah, sure. Trooper, you can step down.
Judge, my only concern is I do have another in-person preliminary examination at 1:30 in Detroit, so I will have to get moving soon.
Okay, let's find out. I mean, for all I know, one of those guys is on the road today. Let's find out.
You want me to, I'll make the call now?
Yeah, go ahead. You want to check and see if we got anybody on our 12 o'clock, which is Collins.
I'm going to step out for this.
Hold on a minute. Who are the officers?
DeVos and Sharkengoss.
Bettendorf is here now. They're supposed to be, so.
Right there. That's too big.
Mr. Kearney.
Hi, Judge. How are you?
I would like.
You got two choices. You can either drive in or you can wait until the prosecutor's got a chance to talk to you about whether or not your guy can zoom in.
So the court won't entertain unless the prosecutor agrees. Won't entertain letting.
Correct.
Entertain. Understood.
Correct. Your guy wanted a live exam, so I'm assuming she's got all her people here. So if she objects to your guy zooming in, then we're not going to zoom. If she's okay with it, then we'll zoom. But in the meantime, I've got the stuff that was scheduled before 2:30. So you can either drive and talk to her personally or hang out where you're at, and as soon as I'm freeing her up, she'll talk to you.
Understood. Thank you, Judge.
Yep.
He indicated he didn't think she she was coming. I just would like a chance to confirm with her that that's the case before I agree to let them do bicycle.
Oh, you mean she being your Vic?
Yeah.
Oh, that's fine. That's fine. When you get a chance,
Okay.
make a phone call, do whatever you gotta do. Are we ready on Collins?
Yes, I think as soon as the defense attorney is done speaking with the client.
Okay.
Next thing you know, it happens.
You haven't seen Cheyenne lately.
Did she too? Did she?
She already popped.
It's just an accepted movie.
And Evelyn just like talking all the time. Can't understand it, but talking all the time.
Oh,
Yeah.
is
Oh.
she? Now that she
And,
is.
and she decided that, because from the beginning, it's like, what you call them, like, I don't know, she'll figure it out.
Right.
Like, I'm not gonna be able to, that's, I'm
That's-
not gonna be able to, not your,
Yeah, right.
so, okay, she'll figure it out. Timmy, the girls would get the most money. So Timmy calls her.
Get outta here.
Right, your day off.
Oh, you want to hear my phone?
So now Evelyn started calling Timmy. So I came down to my office. Because yesterday, she was on her way over, and Cheyenne's filming her while she's talking to her in the back seat. Who do you want to see? I want to see Timmy Papa. Because she just saw me Wednesday night. They were in the hospital. Well, who else do you want to see? I want to see me Papa. Yeah, so I think my official name might be for at least a couple years, me Papa. Like she's Italian or something.
But I think it's cute the way she got Timothy's Papa.
If she knows. Isn't it something about being smart?
Yeah, they are.
No.
All right, appearances on the People versus Christopher Collins, please.
Good morning, Your Honor. Darian Fortier on behalf of the people, P83359.
Good morning, Your Honor. Cameron Bill on behalf of Mr. Collins, who stands to assist in my left, P number 81934.
Thank you. Are we ready?
Yes, Judge.
All right, just before we start, I want to warn you. I started an exam. We're waiting for one witness to get here to take like probably a 3 or 4 minute wrap up, maybe 5, to that exam. So I might interrupt you just for a minute so we can get that one out of here because Mr. Hortis is trying to get downtown for another
That's
exam.
fine.
So it might be just join it. I just wanted to warn you ahead of time. Are we ready?
Judge, I think we'll just have 2 preliminary matters. My first would be, I know we're on Zoom and YouTube and all these things, but I would ask for a mutual order of sequestration. It's an exception for my officer in charge of my victim advocate.
Thank you. Mr. Bell, any objection?
No objection, Your Honor.
Thank you. And you two do not have to jump to talk to me. It's okay if you do, but if you stay seated, you're all right.
My
Go ahead.
second thing, Judge, is that I do have a certified copy of the personal protection order and a certified copy of the register of actions pertaining to the personal protection order, which I'd like to enter into evidence under the court rules 76611 for exam purposes also.
Mr. Bell, any objection to that?
No objection, Your Honor.
May
Thank
I
you.
approach the public?
Come on up. Yep. Just give it to Mary Ann, she'll mark it. You want to mark it as an exhibit, right?
Yes.
People's 1,
And I called in too.
1 and 2.
The register of actions being 2 and the PPO being 1.
Thank you. First witness.
Thank you, Judge. The people called Bailey Millard.
Ms. Miller, all the way up front. Watch your step right here on the frame. Raise your right hand for me. Swear to affirm, tell the truth, the whole truth, and nothing but the truth. You have a seat right here. Make yourself comfortable. State your name and spell your last name, please.
Bailey Millard, Millard.
Thank you. Ms. Fortner.
Thank you. Good morning, Ms. Millard. Could you state your name for the record again, please?
Bailey Millard.
Ms. Miller, are you familiar with Aleo's Coney Island at 9624 Belleville Road?
Yes,
Are you familiar with that address?
it's my job.
Is that in the city of Van Buren?
Yes,
Were you employed at that Leo's Coney Island on, I believe it's June 1st?
Yes, I was.
Are you familiar with a Christopher Collins?
Yes,
How are you familiar with Christopher Collins?
he's my ex-boyfriend.
Do you see Christopher Collins in the courtroom today?
Yes,
Can you tell me where he's seated and something he's wearing?
he's seated to the right and wearing a gray button-up shirt.
Noted for the record.
Thank you, Judge. Did you at any time get a personal protection order against Mr. Collins?
Yes, I did.
Do you remember when you got a personal protection order?
In May 20th? I'm not sure.
If I told you May 26th of 2021, would that sound right to you?
Yes,
And did you give the PPO to someone to serve it?
yes, I gave it to Lieutenant Chip.
Do you know what day it was served?
No, I do not.
Did you see Mr. Collins after that May 26th date?
I'm not quite sure. I don't really remember right now.
You don't remember seeing him or you don't remember?
I haven't had any contact with him in person after that date, no.
Did you see him at Leo's Coney Island at any point?
Yes, I did.
Do you remember that date?
It was the day that Lieutenant Chip served him with the PPO.
Were you there when Lieutenant Chip served him with the PPO?
No, I had just left right after it so that I wasn't present.
When you saw Mr. Collins at the Leo's Coney Island, where were you?
I was outside talking on the phone.
1 second.
Sorry.
Sorry, Judge, just for the record, that's my officer that's going to testify to service, so I just wanted to pause till the.
That's fine.
One more time, I'm sorry.
Are we talking about the day that I was just talking about?
Yes.
Okay, yeah, I saw him when I was outside on the phone with Lieutenant Chip.
What was he doing?
He was in the car and his sister was coming in the building.
Did you have an opportunity to speak with either one of them?
No, I walked away
Why did you walk away?
because she had mentioned to one of my coworkers that she was looking for me.
And did you at any point invite either one of them to come to your work?
No,
Did you want them to come to your work?
no,
How did you feel about them coming to your work?
I felt scared
Why did you feel scared?
because his sister mean mugged me and then walked in the building, grabbed a menu and then walked out after asking for
I'm
me.
sorry, I didn't hear you. Mean mugged you, walked in and grabbed something?
She grabbed a carryout menu, asked where I was, and then walked out.
Did you have any other opportunities to speak with Mr. Collins?
No, I didn't want to.
Okay, was there any other form of communication?
He texted me on a fake messenger account and said that my little brother and mom were home alone and it'd be a shame if anything happened to them.
Okay, when was that?
The same day that my PPO was handed to him.
Okay, was there a break in between when you saw him at Leo's Coney Island and when he texted you?
Yes.
How do you know, you said it was a fake account?
Yes.
How do you know it was Mr. Collins?
Because I don't have any problems with anybody else and he lives near my house.
What did you take that text to mean?
I'm sorry?
She said he threatened her family after getting served with a protection order. The courtroom turned intensely emotional during a hearing involving alleged stalking, threats, and repeated violations of a personal protection order. A terrified woman testified that after her ex-boyfriend was served with the PPO, she immediately started receiving disturbing messages from fake social media accounts. The hearing got even darker when she described a message saying her little brother and mother were home alone and it'd be a shame if anything happened to them. The witness told the court she believed the messages came from her ex because the sender knew deeply personal details about their past relationship and kept contacting her through new fake accounts after being blocked. Then came the chilling moment that changed the entire atmosphere in court. The woman admitted she felt genuinely scared after seeing the defendant outside her workplace right after the PPO was served. She testified that his sister appeared to be looking for her inside the restaurant while he waited outside in the car. The courtroom stayed tense as prosecutors built the argument that the defendant intentionally violated the protection order and continued harassing the victim despite knowing he had already been legally ordered to stay away. Do you think messages from fake accounts should count as criminal intimidation in court?